Hi, welcome to this seminar from Doughty Street and Outy Street, our LGBTQ section. We have three amazing presentations coming up from Alice Irving, Donnchadh Greene and Jonathan Cooper, and then we hope to have time for a short question and answer session. We are on the usual webinar settings, so camera and mics are switched off, but as I say, you are very welcome to post questions at the end, which the panelists, not me, will try and answer. Firstly, a brief word about Doughty Street and Outy Street. Doughty Street barristers have been involved in some of the leading LGBTQ rights cases since the 1990s, when our very own Jonathan Cooper was doing leading cases, and our long-standing head of chambers, Ed Fitzgerald, is currently doing the well-known Cayman Islands equal marriage case for the lesbian couple seeking equal marriage. And our new deputy head of chambers, Henrietta Hill, did the B&B discrimination case a few years ago. Outy Street is a newbie by comparison. It was formed, I may be corrected, but I think about a year ago, to represent our queer community in Doughty Street, and is already, I think, about 20 strong in terms of barristers and staff. In the face of attacks on sections of our community, Outy Street is particularly proud to be inclusive of all LGBT plus people, with none of our initials up for grabs. That's reflected, I think, in our queer identity and the title of this seminar, which I can't unfortunately claim to have been involved in. And I think, as you'll see in the content of the seminar coming up, the reclaiming of the word queer started, of course, with AIDS activists in the USA in the 1980s, out of which grew direct action groups like Queer Nation in the States and Outrage in the UK in the 1990s. For people growing up in that era, that reclaiming and radicalism associated with it was a godsend in an era where we were fed images on the mainstream news of a community on its knees, and in large measure a very passive appearing community on the news, dying, and in many quarters, of course, allegedly, deservedly so. Queer identity, I think, is also a symbol of emphatic inclusivity. It was in the 1990s, at a time when some in the, quote, lesbian and gay community were openly arguing for the exclusion of bisexuals and other minorities, in rather the same way that some claiming to represent the LGB community now argue for trans exclusion. The queer community also embraces intersectionality, and as someone who has faced a raft of new discrimination in work and society, having acquired seen and unseen disabilities in 2018, I really value the queer disability groups like Power Pride and Disability Queer and Here that have become essential to my identity, as was marching in a wheelchair in 2019 Pride, in between mermaids and queer Muslims. So our first speaker is Alice Irving. Alice is a barrister practicing in housing, education and public law, with a particular focus on the rights of people with disabilities. She identifies as queer, and in a former life, she completed a doctorate in legal theory and co-founded the Oxford Student Union's campaign against sexual violence, It Happens Here. As a queer crip, I'm really looking forward to hearing her exploration of the Land Rover judgment and its treatment of disability, amongst other things. Alice.
Thank you so much, Mark. I'm going to be talking about the Taylor and Jaguar Land Rover Limited case today. When we advertised this webinar, we were thinking about adopting an approach like the Feminist Legal Project that you might be familiar with, where you take a case that perhaps is written on an issue touching on women's rights, which hasn't really understood or captured a woman's perspective, and you rewrite that case so that it represents what you would hope the law would do in that kind of situation if it was alive to the experiences of women. And when we talk about Queering Equality Act judgments, we're interested in doing something similar. So perhaps it seems odd that I've picked Taylor and Jaguar Land Rover, given that on many accounts, it's a really excellent judgment and a huge win for the LGBT plus community. And I'll be going through that in a second. The reason I'm going to be talking about the case, which is the first case to recognise Equality Act protection for people with non-binary gender identities, is that, as Mark said in his introduction, those of us who identify as queer and are committed to the queer cause are also committed to intersectionality. And I think that while the judgment gets a lot right about non-binary identities and protection of those individuals, I think it does so at the cost of talking about disability in a way at times that's really problematic. And so I want to challenge us as a community who is in solidarity with all people who share protected characteristics to think about this judgment both as a win, but also critically about how it contributes arguably to the stigmatization of disabled communities. So next slide. So just to get going, here are some fairly wordy definitions that are from the Stonewall resources online, just for those of you who might not be familiar with the concept of somebody being non-binary. So we talk a lot about, in public discourse, about transgender women and transgender men. Largely transgender women are the focus of the public debate. I think what's less well understood is that trans is really an umbrella term that can encompass, yes, transgender men and transgender women, but also a plethora of other gender identities, including people who identify, for example, as gender fluid or non-binary. And again, non-binary itself can encompass a range of different identities. So it might be somebody who doesn't identify as a man or a woman. It might be somebody who rejects the idea of identifying with a gender. So you may be somebody who's agender or non-binary. It might be gender fluid, in that somebody on some days is presenting themselves in a sort of a male presentation or in a female presentation another day. So there's a diversity within all of these terms, and I think we just have to keep that in mind to make sure that we don't reduce any one case or one person's experience to sort of the exemplar of what these terms encompass. If we have the next slide, please, Ryan. So if you've not before encountered non-binary people, here are some famous non-binary people that you may have come across. So Sam Smith on the left is non-binary, musician. Jack Munro, the fantastic food poverty activist, is non-binary. And if you're following the latest season of Drag Race, this is one of the non-binary queens, Bimini Bon Boulash, with the trans pride flag there. And also obviously Ginny Lemon, who's just left the competition, also identified as non-binary. I think there's a tendency for people to think that this is a minority within the trans community. Certainly it's an emergent identity in public discourse, but it is an identity that a lot of people own as their own, and that isn't sort of a population I think that should be ignored, although they have been largely in law for quite some time. So if I could have the next slide, please, Ryan. So the case of Taylor. So Rose Taylor was the claimant, and I think having said what I said about the importance of recognising that every person's gender identity is potentially unique and different, I think it's worth just setting out some of what Rose Taylor says about her identity, and she does use female pronouns. So she describes herself as gender fluid. She's not interested in any kind of surgical transition. She doesn't have a final destination of becoming a female. And we've got expressed here in this quote from some of the evidence before the employment tribunal, some of the anxiety that comes with being gender fluid, and particularly the kind of confused expectations around that. I think a lot of the media discussion around trans, and particularly trans women, fixates on this idea of trans women presenting as ultra femme, and that being how these identities are expressed. And I think really some of what Rose Taylor is saying here captures the pressure that can place on the community, that she's not comfortable expressing herself that way. And in fact, when she did start to express her gender identity at work, she was choosing to present in a female mode, twice a week, and then in other days to continue to dress in a male mode that had been more familiar to her colleagues before then. If I could have the next slide, please, Rai. So the claim itself was, as I say, an employment discrimination case under the Equality Act, and there are a multitude of claims for unfair dismissal, direct discrimination, harassment, and victimisation. And before I go to the really big preliminary question which the case determined, I think it's again worth putting this in factual context to give you an idea of precisely what was happening for Rose Taylor and the kind of factual background to the claim. So in terms of the harassment, the claim was based on a series of unwanted comments being made to her by colleagues at work without there being any particular response by management in relation to those. And those comments included things such as, "I was checking out your dress, looked up, saw it was you, and my jaw dropped. So what's going on? Are you going to have your bits chopped off?" And then her overhearing other people saying, "Have you seen it? I saw it in the atrium. What the hell is that? Oh my God," other people reacting, asking her if it's Halloween. "Don't take this the wrong way, but I saw you as the top half and it didn't match the bottom half. Are you not femme today?" Some other people saying, "The trans community ought to be grateful. Some of their antics have nearly damn turned me turf." And when she reported these things to the relevant HR staff, she was told not to be too sensitive in relation to the reaction of her colleagues. And there were various other offhand comments made. Now, some of the comments also that she found difficult were people who were obviously trying to be nice, but perhaps getting it a bit wrong. So somebody saying, "It's nice to see you in your attire, you have cracking legs." This again made Ms. Taylor feel uncomfortable, and someone else saying, "I think you're beautiful and I think you're very brave." But again, unwanted comments ultimately. So that was the basis of the harassment claim. Ultimately, what flowed from this was that Ms. Taylor made a number of complaints, both about specific incidents in relation to her, this ongoing harassment, and also in relation to the lack of any kind of diversity group or provision or support within Jaguar Land Rover, despite it being a very, very large employer. So there were kind of two strands of her concern. One was we need to make the situation better for everyone, and we need like a long-term strategy for LGBT plus inclusion. And the second was, "I'm being harassed, please do something about it." Ultimately, unfortunately, very little was done. And Ms. Taylor suffered significant impact to her mental health as a result, becoming depressed and experiencing suicidal ideation until she got to a point where she felt so isolated that she said she couldn't continue working at Jaguar Land Rover. She subsequently retracted her letter saying she couldn't continue working when she found out that a queer ally was going to be joining as a colleague, and she thought that perhaps she could cope with their support, but the company wouldn't accept her retraction of her letter of resignation, if it could be called that. And that was the basis of the unfair dismissal and victimisation claim, that effectively this was a constructive unfair dismissal because they had failed to keep up their side of the contract in terms of mutual trust. That led to her leaving employment, and she was victimised in that the decision not to allow her to remain on when she changed her mind was as a result of basically the company deciding that she was a bit of a pain because she was constantly complaining about harassment and pushing them to try to improve their policies. But obviously, to even get through the gateway of getting the employment sort of tribunal to consider these discrimination issues, there was a preliminary question, which is, does a gender fluid person or a non-binary person have a protected characteristic recognised by the Equality Act? And what we have under the Equality Act is the protected characteristic of gender reassignment. So if I could have the next slide, please, Ray. So it had never been considered before whether or not Section 7 could cover somebody who was non-binary or gender fluid. So there's no authority on the point. And I think it's fair to say that regardless of where you sit in the discussions about trans identities and gender identity, I don't think any of us are really particularly pleased with the wording of the Section 7 and gender reassignment. It's a bit of a word salad when it comes to thinking about what gender and sex might mean. Doesn't really make a huge amount of sense. It uses arcane language. A lot of people now find that, for example, the language of transsexual to be offensive. And it raises a lot of questions. So you see in particular here, gender reassignment, so a person undergoing or has undergone or is proposing to undergo a process for the purpose of reassigning their sex. So again, we've got perhaps an unfortunate use of the word sex here instead of gender, depending on what you think those two terms mean, by changing the physiological or other attributes of sex. So again, it's quite clear here that this doesn't necessarily need to be a physical change in terms of surgical intervention, but it's not necessarily clear what I think other attributes of sex might be intended to mean, depending again on whether you think sex and gender, what those two relative terms mean. And in particular, it's not really clear whether this envisages a person, and I think perhaps when you read it, you kind of envisage a person moving from one side of the binary to the other side of the binary. So that's the process that's perhaps envisioned here, rather than somebody sitting somewhere between those two sort of polar positions. It's also not clear when a person begins to propose to undergo this gender reassignment process such that protection clicks in. So there are a lot of questions around the meaning of this provision and how that's going to sort of play out in the context of non-binary identities. If I could have the next slide, please, Ray. So I'm sure any of you who've been following these broader debates will be more than aware of the Select Committee report of 2016, which made certain recommendations in relation to the Gender Recognition Act. And included amongst those was that there needed to be some kind of legal category or recognition for people who are outside of the binary, because right now you can either legally identify as female or male, and there isn't another option. But that report also said that the protected characteristic in respect of trans people under the Equality Act should be amended to that of gender identity, which is more inclusive and perhaps gets around some of the kind of difficult questions around the mixed usage of sex and gender in the current definition of gender reassignment. And the consultation that followed that committee report showed that almost 65% of respondents supported changes to recognise a legal identity for people who are non-binary individuals. But as we know, changes following this report and consultation haven't been made. And so we're left in a position where currently the Equality Act says what it says, and the gender recognition legislation doesn't recognise a non-binary or agender perspective. Perhaps this seemed like a fairly unoptimistic context in which to be trying to bring a claim for Ms. Taylor, particularly if you're aware of the Elin Kane and Home Office cases, which concern a non-binary individual seeking to have their passport updated so that it doesn't say male or female, but simply says X in the context of gender. And they've lost that challenge in both the High Court and then early in 2020 in the Court of Appeal, with the Court of Appeal effectively saying this case isn't limited to passports. In reality, the driver behind this is a broad notion of respect for gender identity. That can't be considered in isolation. The passport question, we've got to leave it basically to Parliament to go through the processes which are taking place in relation to reflecting on what to do about people who are non-binary, and the court refused to intervene. So that case is now on appeal to the Supreme Court. But you could see, and it was a similar argument made in the context of Taylor actually, that there have been proposals to change the Equality Act to be more inclusively worded. There have been proposals to make legal changes to the Gender Recognition Act to include recognition of non-binary genders. Those haven't occurred, so the court should leave well alone, and that's certainly part of what was argued before the Employment Tribunal. We could come to the next slide, please, Ryan. What was really positive about the judgment from a queer perspective is that the court or the tribunal was willing to push a little bit further than that and to say, right, so we think the wording of Section 7 is ambiguous. Therefore, we're allowed to look at the underlying sort of Hansard and other parliamentary materials to help us understand what this should mean. And when they looked at those underlying materials, it might come as a surprise to you, but a lot of the debate that happened in Parliament when the Equality Act was passed was far less binary and rigid than some of the debate that's occurred around the gender recognition legislation, for example. So it became quite clear from an analysis of Hansard records that, for example, the Equality Act sought to deal with issues around discrimination, moving away from a medicalised approach. So it was quite clear that there shouldn't be surgery or any other kind of medical process required to have the protection of the Equality Act in relation to gender reassignment, which you might say is in quite stark contradistinction to the debates around the Gender Recognition Act, and the fact that the big argument there is that the process is currently heavily medicalised, and the proposals to allow for self-ID would kind of take away those burdens from the trans community. Here's the court recognising that the Hansard history leading up to the Equality Act itself sought to push for a non-medicalised approach. And if you read the judgment, you'll see the portions of the parliamentary debate they rely on in that regard. If I could have the next slide, please, Rai. And really the crux of the decision comes in paragraph 178, where again, having read from some of the passages of the debate that occurred contemporaneously when the legislation was being passed, they concluded again that it's nowhere near as rigid or binary as perhaps the current debates suggest. But at the time that the legislation was passed, there was recognition of a spectrum, there was recognition of a diversity of experience, and importantly, and I'm going to read actually from a particular quote that preceded this conclusion here. There are lots of ways in which being someone who has a particular characteristic of gender reassignment could be manifested. For instance, it might simply be making the intention known so that you're proposing to change your manifestation in some way, even if you don't take a single further step. So you might start to dress or behave like someone changing their gender. That would mean you are protected. But if the employer is notified of that proposal, so that you're proposing to change your gender, that's enough. And that there's a clear obligation not to discriminate even as soon as you've expressed that intention. And again, I think that's a really strong contradistinction to where the Gender Recognition Act debate is at. And that was the debate that was happening in Parliament when the Equality Act in 2010 was passed. And on the basis of that, the court reaches this excellent conclusion, which is that gender reassignment can encompass people who are non-binary, who are gender fluid, and that transitioning doesn't mean moving from A to Z. It doesn't necessarily even mean having a particular endpoint in mind. And that was what was partly interesting about Ms. Taylor's evidence, is that she was quite clear that this was a lifelong journey. She had a current sense of her gender identity, but she wasn't sure that that was necessarily stable, and that she might change her view as to whether she was gender fluid or a trans woman or so on at different points. So this is an enormous win, and there's not much reimagining, I think, that I need to do here to bring this judgment in line with what we as a queer community would want to see. And I do think it's fantastic that the Employment Tribunal were bold enough to look beyond the current kind of tenseness of the debate and to go back to the Equality Act parliamentary debates and say, no, the material is here to support a broad and inclusive position. Can I have the next slide, please, Rai? So I'm going to whiz quite quickly through just the underlying aspects of the claim and how those were resolved, because I'm mindful of time and I'm hogging the attention here. So basically, the harassment action was successful. The approach of HR had been to tell the claimant they couldn't do anything unless she named names. And the court said this is absolutely incorrect. There are lots of obvious reasons why a person with a protected characteristic isn't going to want to finger their colleagues and say it was them that was, harassing me. There were other things they could have done, such as sending out a clear notice stating that this kind of behaviour was unacceptable. Next slide, please, Rai. Bathrooms. Initially, she was told to use the disabled toilet. And we'll come on in a second to a bit of discussion about that. And then to use whichever toilet felt comfortable. Again, this was criticised. Effectively, it put the onus on the claimant to decide and to deal with any kind of challenges by colleagues who are unhappy with their choice. There needed, again, to be a clear position taken and a clear policy and a clear communication of that policy to ensure that there wasn't harassment of the claimant. And this put undue pressure and stress on her. So again, this was found to be a failing on the part of Jaguar Land Rover. Next slide, please. And another interesting part of the judgment is that the claimant, she's really remarkable. Through all of this, she was working incredibly hard internally to set up an LGBT+ support network. And she was doing mentoring work with children at schools and all sorts of things. And I think we see this too often, which is somebody comes forward with a complaint, they're willing to help and provide their perspective and lived experience. And then the company sort of jumps on that as the solution and says, okay, well, you do all the work for us and fix our failings in this regard, write us our policy. And again, the court was very critical of this. They effectively said she was left in a position where she was having to justify doing diversity work alongside her other work. She wasn't supported. And this was a big part of what led to the burnout situation that ensued. Next slide, please. Another criticism was that when it became apparent that the claimant was very anxious, distressed, had said they were depressed, were now medicated, and were thinking about suicide, the response of the defendant was to refer the claimant to occupational health. And the problem with this was that it basically said, you're the problem, go and sort out your mental health, without dealing with any of the underlying causes of what had led the situation to be a problem in the first place. And the court characterised this as a health and safety issue that wasn't analysed properly, that the claimant had been put in this position, that her health had deteriorated. We have a next slide, please. So ultimately, the claimant was successful and she was awarded aggravated damages because of the sheer extreme lack of regard for her and how there was nothing in place. The managers were not trained to deal with this at all, but also because of how the case was conducted before the employment tribunal with some frankly quite distasteful cross-examination suggestions. For example, if you were really suicidal, wouldn't you have left the job earlier? This kind of thing. And that the tribunal were very, very hard on that, and the award of damages was significant. So why do I have a problem with this judgment? There are a couple of bits that I'm really uncomfortable with. So this is paragraph 23, where the court reaches its conclusion in relation to the first response that the claimant got when she asked about what toilet to use. And they said, use a disabled toilet. Now, the second part of this paragraph, I'm fine with. Disabled toilets are for disabled people to use and should not be used by other people. I think that's fine, that's respectful. The first part of this I have a real problem with. Telling a transitioning person to use the disabled toilets is at the very least potentially offensive because it suggests their protected characteristic equates to a disability. Okay, so the suggestion here is obviously that it's a negative association to say, well, you're like a disabled person. That's a bad thing and that's offensive to say to somebody. And I can see what the court's reaching for here. So they're trying to identify or conceptualize the harm to the claimant of being associated with another group that's stigmatized, because disabled people are stigmatized. But the difficulty I think that they've run into here is in trying to identify that harm of saying, well, you're like a disabled person, and that's a stigmatizing thing to say, they've in a way reinforced the stigmatization of the disabled community. So they've, you know, in the same breath, and I know other people have stumbled across this paragraph and felt really uncomfortable, said, well, we wouldn't want to say that you were like a disabled person because that's deeply undesirable. And so I do think that when we're thinking about an intersectional approach, we should have trouble and some concern about the way that the judgment talks about disability. And we want to say, yes, absolutely, disabled toilets are for disabled people to use, but it's not a negative thing for a person to be to have the protected characteristic of disability. And perhaps in conceptualizing why this is offensive to a trans person, we need to express this differently. I think the key issue here is really that you're saying, well, this is too hard basket for us to actually recognize your gender identity, whether that be putting in place gender neutral toilets or allowing you to use a male or a female toilet as you wish. And it's sort of shoving this off into a, well, we'll just put you into another category that, you know, that is in fact there for disabled people. But that's really what the problem is. It's I don't think it's correct or respectful to say that the difficulty here is that you're being likened to somebody who's disabled. So this is one aspect, if I were to rewrite the judgment, that I would definitely rewrite. Can I have the next slide, please, Rai? I think the other thing that's missed perhaps as a trick here is And it's funny because the court almost tips their hat to it. So when they talk about the Equality Act trying to move away from the medicalisation of protected characteristics, the court itself says perhaps we haven't achieved that entirely in relation to disability. And yet the way they talk about the claimant's mental health still arguably has a really medical model feel about it. Now, it's fair enough that the claimant didn't bring any claims on the basis of disability, and it's not clear whether or not they would have fitted within the definition of disability. But I think there's a tendency to forget that somebody with a long-term mental health condition, or a person who might, for example, have a health condition for probably 2 years or more. So if you can say, well, the claimant had become depressed, it was likely they were going to be depressed for at least 2 years. You could potentially bring them within the definition of disability within the Equality Act. At that point, I think you should be thinking about, well, what rights and other means of analysis does that engage in this case? And the court doesn't really grapple with that at all. So they complain, and rightly so, about the referral to occupational therapy, reducing this to a medical problem and putting the onus on the claimants in a way to sort out your mental health without dealing with any of the underlying causes. But they frame it as a health and safety issue. I wonder whether that might have been framed also as potentially a disability or reasonable adjustments issue. So you have a person who is presenting to you as depressed with suicidal ideation. They say they're taking medication. Depending on how long-standing that is and the impact on their day-to-day activities, that sounds like it might be a disability. So potentially, we should have been thinking about what reasonable adjustments should have been in place to support the claimant. And also, if we're moving beyond a medical model of disability to a social model of disability, we'll be thinking about, well, what aspects of the environment are disabling? And those aspects include the harassment and all the other things that are unsupportive to the person's mental health. And that's an analysis that could have been used, that could have pushed that discussion of health and safety even further to say, well, if this is actually meaning that this person is coming to a place where they're disabled, what about the environment is disabling? So I just wanted to leave that as a final thought and to say that I think the case is fantastic, and I hope that maybe it might influence the Supreme Court, although it's in a different context, obviously, when they're thinking about this challenge to the failure to recognise non-binary identities in passports. But I don't want us as a community to forget that when for us as a queer community shouldn't throw other people with protected characteristics under the bus. And I do think that this judgment fails on that front in relation to how it deals with issues potentially relating to disability. So that's it from me. And if there are any questions arising, I'll deal with those at the end of the session. Thank you.
Thank you, Alice. I think that was long, but worth every minute of it. For me, it was a really insightful presentation, both the limitations of the Equality Act and Gender Recognition Act, and the limitations of this judgment, but also everything that was good about it, and everything that was really problematic in terms of disability, which for me reminds me of the very early arguments in which one of the first cause célèbres and deliberation was to prevent it being described as a disorder, which was entirely right. But nowadays, we would see that through a much more intersectional perspective. Okay, I now turn to Donnchadh, who is a barrister at Doughty Street, practicing in community care, unlawful detention and inquests, and with a particular focus on related public and discrimination law challenges. He identifies as queer. Prior to coming to the bar, Donnchadh worked for Liberty and was an asylum support assistant for LGBTI+ refugees at the UK Lesbian and Gay Immigration Group. UCLIG, of course, did and does incredibly good work on LGBTQ asylum and immigration cases. I had the pleasure to work with it a lot in the immigration team, and of course, the Doughty Street immigration team did and continues to do great work on queer, gay, and immigration and asylum cases. But he is going to look at the trans discrimination case of C against Work and Pensions Secretary in the Supreme Court. Brenda Hale gave the only judgment. She also wrote the foreword to the book that came out of the Feminist Judgments Project, in which a number of her own judgments were reimagined from a feminist perspective. But Donnchadh's going to do this one from a queer perspective. Donnchadh.
Thanks very much, Mark. Yes, I am going to take aim at Lady Hale in this in this reimagining here. As many of us admire a lot of her legal reasoning, but I would say in this example it falls short. And so, Ray, could you give us the next slide, the first slide, please? Thanks. So, a bit of the background about C and the Department of Work and Pensions. So C was a woman who held a gender recognition certificate. In fact, she was one of the first people in the country to access it. She'd become unemployed in 2010 after being let go from a managerial role, and had struggled to find work since then. And so this is a couple of years on, about 5 years later, when the case properly started. And so she'd been claiming job seekers allowance since then. To claim her job seekers allowance, she had to go to the job centre in person every 2 weeks. On the IT system that in which she had to fill in forms and do stuff, and the staff had to speak with her about her different her claims and different work she was looking for, it listed the fact that she had a gender recognition certificate. This at the first time when the claim was initially brought, it was specifically mentioned. And there was also a second policy that was in place. So there was a retention policy that retained that information about her gender recognition certificate. And then a separate policy called the Special Customer Records Policy, which was used for customers who required extra protection for privacy reasons. And so this meant that if you accessed the information, it was limited and only certain people could access it and different points like that. And the overwhelming majority of people the court heard were trans people who accessed who use this SCR policy, but there are also individuals who are maybe victims of domestic violence and victims of honor-based violence, and those who are witness protection or whatever other reason who are also using the policy, but the majority tended to be trans people. Next slide, please, Ray. So what happens when these individuals at the job centre click on Miss C's in data input? It would pop up saying, you're not allowed to access this, only certain people can access it. Now, if you know from your experience, and maybe you've accessed Miss C's file, you know that she's trans, and you'll know that this is the sign that comes up effectively when people are trans. Lady Hale talked about it being possible, if not probable, that the inference would be made. So what had happened was, at the time, because the retention policy disclosed her gender recognition certificate, or the fact that she had one, she'd experienced a number of distressing incidences, which basically indicated that they hadn't been protecting the privacy, they hadn't been doing the job they were doing. There had been negative comments about her and negative comments about her identity, that were clearly distressing, so much so that it had to be that she had to transfer her files to a different office. And as it was said in the judgment, C had become concerned about her history. It was recorded by the DWP and the effect that this was having on her interactions with the officials. Next slide, please. This is the three main grounds that she brought at the outset. As is an Equality Act event, it would be interesting to look at the other points, and I will kind of touch on them, but we're looking explicitly at the Equality Act here. So the three grounds she brought at the High Court about the retention policy, so the fact that they had her gender recognition certificate, or the fact that she had one, and the fact that there was a policy that would prevent people from discovering it. Breached her Article 8 rights. It breached her Article 14 rights, so Article 8 right to privacy, and her Article 14 right, freedom of discrimination, in conjunction with the Article 8 right, and it directly and or indirectly discriminated against her under the Equality Act. Next slide, please, Ray. So at the High Court, they struck down the policy, the retention policy, because it said it was held that it wasn't in accordance with the law. The policy wasn't clear. It wasn't. It didn't have any precision about how this was to be decided about when it would disclose these things, and so it was struck down. However, Mr. Justice Simon continued to hold that it was proportionate means of achieving a legitimate aim, and the two legitimate aims that were held and were continued to be held in the High Court, Court of Appeal and Supreme Court were for fraud detection and pension calculation. So effectively, if you transitioned at a certain age, it would impact at what age you could claim pension. And I didn't really quite understand it because it's quite a lot of complicated pension law, and there's a reason why I'm not a pension lawyer. And then they also rejected both all discrimination grounds under the Equality Act and under Article 14. They said it wasn't discriminatory. Next slide, please, Ray. So what happened in the interim between the High Court and the Court of Appeal was that the retention policy was clarified. The reference to the gender recognition field in the database was masked, so no one could see it if you were just looking at her folder for whatever reason. But it still remained the case that you could still draw an inference from it, and this is on the basis of what Lady Hill said it was a possibility, if not a probability. Next slide, please, Ray. And so Elias, Lord Justice Elias, held that Article 8 was indeed engaged, but it was still proportionate. Article 14, Equality Act discrimination claims were not upheld, and even though it was possibly indirectly discriminatory, it was held to be justified for the same reasons. Now, at this point, the claimant must have been allowed to amend her claim because the new ground of that it was incompatible with Section 9 of the Gender Recognition Act 2004 was raised, that they said that, well, if you say that I get this gender recognition certificate and Section 9 quote says the person's gender becomes for all purposes the acquired gender, you have clearly breached this point through the policy. And so she raised that, but that was also rejected. And I'll go into a bit more about what happened with that in the Supreme Court in a second. Next slide, please, Ray. So she takes her case all the way to the Supreme Court, where she encounters Lady Hale and Lord Kerr, some very liberal judges. And she brings forward that it was inconsistent with the Gender Recognition Act 2004. There was incompatible with Articles 3, which is the first time this was raised as well, 8 and 14. It was an infringement of sections 13, 19, and 26, so direct and indirect, and harassment as well was also raised given the incidences that occurred in the offices of the job centre, but the failure to do anything about it created this harassing atmosphere. So next slide, please. So Lady Hale, in her judgment, opens with this quote called, "We lead women's lives, we have no choice." And she goes on to discusses different points about perhaps biological differences or social differences about sex, and looks a bit in gender, but there's a bit of a confusion in the terms in a way that many people wouldn't quite appreciate. And she kind of discusses these points and how people feel at ease with their gender, and talks about what is often described as quite regressive language now about not feeling okay in your body. And so it's kind of striking out as maybe not going to be the most favorable judgment to someone who's really concerned about their identity being misidentified effectively, and this causing not only personal difficulties, but difficulties in how she's accessing benefits in this from the state. And it also discusses gender dysphoria. I'll just put that quote there if you want to have a short read of it, but it talks about this term about history, and it also talks about, helpfully, it talks about the fact that there is an increase in transgender hate crimes, transphobic hate crimes, and that people are victim to that, and that is increasing. And in the last 4 years since this judgment, I think we've seen an exponential increase on that as well. Next slide, please. Sorry, I should have said it outset. What often these judgments do is that the Feminist Jurisprudence Project is that they look at the reasoning and they tackle it and they point out the points that are in it, and then we reimagine it. So I'm just going to go through the reasoning a bit more first before I reimagine it. So Lady Hale acknowledged that disclosure was still possible, that the secret or the secure policy wasn't doing its job, that the error message would pop up, and that the access infers what the probable reason is. So the advisor may well be able to put 2 and 2 together, Lady Hale says. And there was also a harm that was acknowledged to this new policy. So the policy effectively meant that if you needed access to Miss C's database or her folder, it could have a delay, and it could cause a delay of late payment up to 3 days. So we have this kind of intersecting point about an individual who is reliant on state benefits, as well as the kind of broader point about her identity. And acknowledges that there was a reference on several occasions to her transgender status. And again, I already highlighted this, that she had to transfer office. Next slide, please, Ray. So Lady Hale continuously said this phrase, rewrite history, which I'll look at when I reimagine, and it held that she was bound by the case of J&C, and so that looked at what a gender recognition certificate meant in terms of an individual who had transitioned and whether they could be listed as their child's father now that they had transitioned. And it basically held this point that they could not rewrite history, and that the appellants were effectively bound by that. I don't know whether they argued that they shouldn't be bound by that anymore and the Supreme Court should take a different view, but it effectively shows the kind of limits of legal reasoning that can happen. You can end up bound by a judgment in a completely different context that is limiting your ability to argue your case. But Lady Hale did acknowledge that it's a very serious matter, that it goes to the heart of how the appellant and others in her situation relate to the world and the world relates to them. Next slide, please, Ray. So the DWP continued its argument that it was that the legitimate aim and the justification were the need to retain information for the purposes of calculating entitlement to state retirement pension. Again, I'm not going to pretend to understand that. And to identify and detect fraud. So it was said in the judgment that DWP workers were at the front line of those who identify fraud, that if someone came with C's original birth certificate, so not the one that had been corrected in light of her gender recognition certificate, but came with her original one, would be able to immediately spot something was wrong, and it was an important point about the fraud. Next slide, please. Oh, can you go back a slide? Actually, sorry, I put two slides together. Yeah, and so it also talked a lot about the Department of Work and Pensions, how complex the computer system was and how it couldn't continue to handle any more changes. And we've seen that in the context of some recent universal credit judgments about how they've had to amend the system in light of individuals and how they make payments in different times and how that discriminates against people. But because this was the old system, so and during this case, effectively what happened was job seekers allowance became universal credit. And so because it was the old system, it would have been quite expensive for the DBWP to have changed anything. And so there is something in that about stretching that too far when there's universal credit now is the benefit that people were on. Next slide, please. So if I were to begin reimagining, if I were to become president of the Queen's Bench Division or president of the Supreme Court, if I dare put myself in those positions, what are the limits of my reasoning? I personally have never transitioned. I'm sure that there would be plenty of evidence about that before me if I were a judge. And so there's limits to how much I can really speak or say that we would imagine this from the perfect trans perspective. Indeed, often the case is if you've spoken to one trans person, you've done exactly that. You've spoken to one trans person. Everyone has a different experience of how they wish to be identified and how they understand their gender identity and any other perception of themselves that has been the case before. And so we look at this thing, and also it kind of touches on really important points for the queer community. It talks about our identity. When I myself, when I look back at some photos of myself, or my mum tells me stories about how I set up nail bars when I was very young. What does that say about our identity? That's me looking back and querying my own history and looking at other different points that points to. And I'm also really passionate about digital rights. I think how queer people are perceived. We now, well, not now, but historically we are in my living memory, we've had a very progressive judgment in the sense of our progressive governments in terms of how they understand LGBT people and how they've moved forward and forward and forward. Maybe that's not the case now. And so even though this is the case, even though the governments amass more and more information and the digital identities are amassed, what happens when we have governments like this one, and maybe worse governments in the future, that have all this information on individuals, and then they use it for whatever purposes? We have this big record of people who have had gender recognition certificates. And what if we have a less benevolent idea of how that data should be used? So next slide, please. So I would open not with a quote about we are women, and this is what being a woman means, and looking at biological and other points like that. I would open with Sophie, who recently died, a producer and an artist who makes quite lovely, noisy hyper pop. And she, in her bridge, she says this: I was just a lonely girl in the eyes of my inner child, but I could be anything I want. And no matter where I go, you always be here in my heart, here in my heart, here in my heart. I don't even have to explain. Just leave me alone now. I can't be held down. I can't be held down. And so if I were to reimagine this judgment, and obviously it's subject to how C herself would identify and how she would do that, I would take this quote from the really wonderful poppy song Immaterial and put it right at the center of how we're thinking about identities and how we're thinking about an individual who comes to claim their job seekers allowance and how they come to talk about who they are and to effectively correct the state's mistake. Next slide, please. So I would probably talk about the very simple fact that she is a woman and she is seeking to claim job seekers allowance. And the state got it wrong. The state on their form, for whatever reason, at one point had male. And she is now telling them, you've got it wrong, you need to fix it. And so how we immediately, I would, if I were querying this judgment, I would completely put the onus on the state to say, how are you fixing this error that effectively you have made? And so this is the immediate switching of not saying, oh, well, this is what they've done for her, and this is how much they've made to her, and all the adjustments, for want of a better word, they've made about her. And how do we centralize her autonomy? So if we have this immediate switch where she gives her identity and that's the end of it, everything else is deleted from beforehand, what about, as Alice was talking about earlier, about people who are gender fluid, non-binary, who on some days may present more male or more female, and how would this judgment sit squarely with that? Because if we're going to take an intersectional approach and we're trying to include as many people as possible, that is how we can have this. And so that might be a slight limit to this judgment, and actually shows the limits of, even if we queer judgment, there's limits to legal reasoning in general. Next slide, please, Ray. We get rid of the concept of erasing history or rewriting history. I can't speak for trans people. I'm not a trans person myself, but the idea that the individual, as Sophie was quoting to earlier, I was a lonely girl in the eyes of my inner child, that there's a sense of always being who they always are. And it's the world, as I've said, about putting the burden on the state that didn't know it. And it was just, and it's not coming out, it's letting people in to your identity and who you are. And so can discrimination and direct discrimination under the Equality Act hold this? So we've already talked about Alice's point about the limits of, or the perceived limits of gender recognition of the Equality Act. What are the points? Would legitimate aims such as pension age and fraud be okay? Again, I'm not going to speak about pension age, but fraud was an interesting point. They were saying that if someone presented with her old certificate, her original birth certificate, that the DWP would have known and done something about it. But actually, that's not really a harm reductionist view of how this is. They're not thinking about the harm that that would do to see that would have actually been quite a distressing experience for her, and not really in the DWP's interest, because quite clearly, if she is a woman and there's a person who presents as a man and says, I am C, immediately that's going to flag up as something that is wrong, regardless of whether it's a policy or whatever. Next slide, please. So if we're kind of looking at this judgment differently, those are the kind of things that I would do. Those are the points that I would queer and look at it from a different perspective. And I just highlight these two other things. Disclosure is a documentary on Netflix, which is really great. It looks at the history of transgender portrayal in the media, and particularly in film, and with some really great examples as well as some really terrible examples of how media portrayals change. And also automating inequality, kind of centering the point that C was a woman who was on benefits, and this is the kind of digitization of benefits that we see, and those that are being subject to automation in their receipt of benefits. And as things progress and things look like they're going to get more automated and more artificial intelligence, what does that mean for poor people? What does that mean for queer people? Thanks very much for listening in.
Thank you, Donnchadh. That was a really, I thought, interesting analysis of the concerns about Brenda Hale's judgment, including that use of regressive language and the reimagining it from a queer perspective, as though it sees autonomy that's central and the onus is on the state to right the wrong, I think was really, really useful. And I was just looking at Brenda Hale's introduction to the Feminist Judgments Project book, and she notes that could do better as a mark which some of the authors have given to my own best efforts. And she says that there are cases in here which I would have loved to be able to go the extra mile on and write the judgment which the feminist judge has written. Sometimes I did not, because it was more important to reach the same result by a route with which the whole court could agree. Sometimes I did not because of the huge practical implications which might actually imperil the decision if they were exposed. Sometimes I did not because I had not seen the case in that way. So it would be interesting to know what she said to the queer rewriting. Okay, I turn finally, and with apologies to anyone who thought that we were finishing on time on our hour, I'm afraid I'm useless at cutting speakers off when I'm very interested in what they're saying. So we will be running on a bit. And last but not least, we have who I think must be the senior queer in Chambers. I think our very first out person in Doughty Street and Oughty Street from the early 1990s, who really needs no introduction, but has been involved in leading cases from the 1990s, including the gays in the military litigation. Of course, in the 1990s, other queers were invisible. And he still is. And he's going to give us what looks like an amazing presentation, a complete overview on the relevant Strasbourg case law and the development of case law on gender identity. Jonathan.
Okay, well, thanks, Mark. And it's a real pleasure to be here. And I appreciate that some of you will have to go because it's 4 o'clock and we're scheduled to finish at 4. And I'm proposing to sort of whiz through this. And so we can have a bit of a discussion as well, because obviously we all want to do that. My understanding is that you've all been sent two notes that I wouldn't call them papers, 2 notes that I've drafted that is going to cover what I'm proposing to look at today or this afternoon. And I'll try to do it in less than 10 minutes. One is this update on what's been going on in Strasbourg, and the other one is a reflection on how the Strasbourg court has dealt with trans issues and how they are increasingly approaching trans issues. And I'm provocatively asking, whether the Equality Act is keeping up. And I think obviously on a level, of course, the Equality Act is keeping up in relation to these LGBTQ issues. But I think there's a lot that we can learn from what's been happening in recent years in the Strasbourg court, as well as we can learn a lot about how the European Court of Human Rights is beginning to approach trans issues. But before I start more formally in terms of going through my PowerPoints, I just wanted to pick up on the point that Mark raised at the beginning and introducing himself, and my colleagues have also introduced themselves as queer. I'm perfectly happy to be defined as queer. To be honest, I'm perfectly happy to be defined in any way people choose to define me. But I do understand and I do respect those that get quite profoundly hurt by the term queer. And it is, of course, something that has been used to demean and degrade, certainly me, for a large chunk of my life. And it's been used in terms of violence towards me and others for moments during my life. And so I get the problem with the term queer. The only reason why I'm happy to use it or content to use it is that whilst we remain unequal and whilst our dignity is denied us, we are queer. And I appreciate how the huge strides, of course, they're amazing, but whilst we remain unequal and whilst we remain denied, we are queer. And when I say we, it is a sort of global thing. Whilst LGBTQ people are denied the most basic form of protection across the globe, we remain queer. And to me, it's all kind of caught up in the notion of human dignity and the idea that people are still happy to lump us into this sort of homogenous group of faceless people who have no identities and no individual personalities or characteristics. And we just get cast in this mold. We remain queer because that's the tactic of that conduct. Because by doing that to us, we do become, we become so othered that it's perfectly appropriate to treat us in that way, and therefore we are queer. I mean, Mark raised the case that's going on at the Privy Council next week, and there was one last week around equal marriage in UK overseas territories. So there is a direct link. These people are UK citizens. And whilst equal marriage is being denied UK citizens in jurisdictions which are under the which are part of the United Kingdom and under the authority of the United Kingdom, whilst people don't have the same rights as others, we all remain queer, in my view. But let's turn quickly to this presentation. So Ray, if I could just very quickly look at the first slide. I'm not really going to dwell on this, except for those two cases at the bottom there. There's the case against Spain and the case against Portugal. And they both are sort of two sides of the same coin, one won, one lost. They both involve famous people in those jurisdictions who, and in the Spanish situation, this woman identified as LGBTQ is not, the state hasn't done enough to protect her, but yet in Portugal, it was perfectly acceptable for a rather repulsive, offensive joke to be made about a gay man who appeared on TV. I raise them only because I think it's interesting that these things are playing out in the Spanish court, in the European Court of Human Rights. And obviously, my preference is to go for the Spanish version, where the court was very clear. There are positive obligations to protect people from this kind of casual, rather unpleasant homophobia that she was subjected to. The following slides in my presentation, so if Ray goes through them, they concern marriage and families. You know, something I'm not going to bother with them. So Strasbourg continues to let us down over marriage. And maybe if you want me to do another session on that, I'm happy to do that. But let's skip it for the moment to make up some time. So carry on going through, and then we should move to hate. Now, this is really interesting, where we've seen from 2015 a completely radical change in the approach of the European Court of Human Rights to LGBTQ issues. And that is, things are being located where they should always have been located, i.e. in inhuman and degrading treatment and punishment, if not torture. Since that case there, the first one, the Ident-Ober case against Georgia, we've had increasing situations where the court has actually called it out for what it is. And it's just remarkable. And I remember the first article I wrote about LGBTQ, or gay and lesbian rights as it would have been then, before the Strasbourg court. It was in the 90s, the mid-90s, maybe even the early 90s, oh, let's say the mid-90s, for the Inter-Rights Bulletin. And I referred to it as, I'm a bit, but actually I'm not, I think I'm quite proud of this. I referred to it as the European Court of Heterosexual People's Rights, i.e. this inability of that court to do anything but address criminalization in the relation to LGBT rights. And then now, if you just think about it, 20 years later, they are locating those rights where they belong. And so when we're now looking at the treatment of LGBT people and the failure to properly protect LGBT people, and we feel comfortable in locating that in the absolute prohibition of inhuman and degrading treatment and torture, I do ask myself, or I ask you, all of us, where does that leave the Equality Act? Is it adequately protecting LGBTQ plus people if they're looking at it through the lens of discrimination, whereas actually the reality is, as a community, LGBTQ people have come from a long and recent, if that's possible to be long and recent, i.e. it's not ended, or if it has ended, it's only very recently ended, periods of persecution. I mean, that's why now I think we need to be re-asking ourselves, how do we get the equality that we are entitled to in the United Kingdom? Can we get it through the lens of equality? Or should we be saying, actually, you know something? We need to have redress for the persecution that we have been subjected to and that we are still subjected to. And that sort of denial of our history, the denial of our persecution, means in many respects that persecution still manifests itself, albeit differently, but it is still there as part of the backdrop to our lives. So I'm just going to point out that there have been two cases against Georgia in where Article 3 was found to violate, one case against Romania, and a very interesting case just last month, middle of Jan, against Croatia, where this poor woman just dancing with a couple of her girlfriends in a bar in Croatia, in a bar, is subject to the most foul treatment and violence. And then, of course, the police fail to deal with it adequately. And that is a violation of Article 3. And so I really feel that Strasbourg is beginning to lead again to really bring the human rights of LGBT people, full center and talking about them as what they are. I just want to just very quickly, if I could, Ray, if we move to the final slide of this section, if you could just go down to move into asylum and immigration. And then it's the next slide. As you may know there, we'll stop here, thank you so much. We finally get a recognition at the Strasbourg level. I know our Supreme Court, or House of Lords as it then was, has done this in relation to asylum seekers, but they haven't made it absolutely clear that to return somebody to a jurisdiction which criminalizes them is an Article 3 violation. And we see it clearly now, in this case against Switzerland, to return this guy to the Gambia where he was from, because they criminalize in the Gambia, is inhuman and degrading treatment. And that is important. It is very important. And a couple of the other cases that we skipped over too quickly talk about how it is actually fine to say you can't be homophobic, because if you're homophobic, you are undermining and denying the dignity of others. And therefore, this isn't some free speech issue. Your homophobia is so extreme, or homophobia in and of itself is so extreme that it denies the dignity of others. So just jump now to the trans issues, which is the next slide, if that's okay, Ray. I just want to remind everyone how slow the Strasbourg court was in really dealing with these trans cases. I mean, for those of you who were around back in the day when Mark and I were messing around with all this stuff, we were constantly being knocked back on the margin of appreciation, and the Strasbourg court constantly saying, well, we know it's a violation, but we're not going to find a violation because we're going to apply the margin of appreciation. What a dodgy set of reasoning. But of course, the minute that they did in Christina Goodwin's case, they did start to really acknowledge some of the reality of trans people's lives. And you've got the quotes there, which are definitely worth reading. That talks about the stress and alienation from the discordance between the position in society assumed by a post-operative transgender person and the status imposed by law which refuses to recognize the change of gender. You see the Strasbourg court becoming much more understanding, much more empathetic. But the key one is, if you could go down a slide, please, Ray. The key is, oops, sorry, let it come into focus. No, I think we've gone too far. Oh no, we haven't. The important thing that's happening now is, and it starts with that case there, the AP Gasson and Nico against France, where the Strasbourg court is recognizing that a transgender identity isn't just about the binary issues that Alice so beautifully described. You're either pre or post, or you're going from A to Z. They're beginning to recognize that actually there's a whole spectrum there. And then if we move to the next slide, and I'm not going to say much more after this on trans issues, you've got this very important case of X and Y in Romania, which was, I think, in January, at the beginning of this year. And it is worth reading what they said. So this was two trans men who did not want to go through the kind of gender reassignment surgery that they were being required to go through. And the court held that domestic courts have presented the applicants who did not wish to undergo a gender reassignment surgery with an impossible dilemma Either they had to undergo the surgery against their better judgment and thus forego full exercise of their right to respect for their physical integrity, or they had to forego recognition of their gender identity, which also came within the scope of the right to respect for private life. And they talk about how vulnerable these guys were and how anxious and how humiliated they felt. And so you see with this X and Y judgment against Romania that Strasbourg is sort of jumped ahead even of the UK and the GRA and the Equality Act. And we're going to be having those rich, fertile, wonderful arguments to be had from that case. And the other thing that they've been saying, which you can see in the rest of the slide and the presentation that you've got, is that the Strasbourg Court talk about the fact that these things need to be done quickly and efficiently and not impose agony and stress on people. And so therefore, of course, we know the GRA was a remarkable moment of its time, but it is of its time. It is now really a dinosaur and really does need to be revised. The government should be doing it, but obviously if the government doesn't force it, the courts will. So that's all I'm going to say on trans developments in Strasbourg. I just want to flag up this thing around Baroness Hale, who seems to be coming in for an awful lot of grief this evening or this afternoon in a number of these cases. And the thing to look out for is, of course, Gareth Lee's case in at the Strasbourg Court. I am an intervener in that case, so I think that probably puts me in a bit of a delicate position in what I can say about it. But the Strasbourg Court is looking at it. You'll recall Gareth Lee was hoping to get a cake with ICE saying how much he believed in the freedom to marry of same-sex couples, his belief in equal marriage, gay marriage, and that cake was denied of him. He just pitched up at any old baker in Northern Ireland, and they said, no, you can't have that cake because it offends our religion. All I would do is just to refer you to Sandra Fredman's work, Professor Fredman at Oxford, just an outstanding thinker on equality, and her criticisms of the case are really based upon the fact that the court, Brenda Hale's judgment, adopted a standard approach to equality law, and Sandra Fredman's point is they fundamentally failed to address the real inequality in this situation. And the real inequality in this situation is being a gay man of a certain age, he's a bit younger than me, in Northern Ireland, coming from a jurisdiction where the Strasbourg Court had to force them to decriminalise, where every single step of the way with any notion of protection for LGBT identity had to be dragged out of the Northern Irish government. Those are your disadvantaged people. Those are the people that need equality law to protect them, to give them the rights that they properly deserve and need. And that particular right is that we can pitch up in any baker and ask for any cake to be iced with any message that we want. The fear and threat that Gareth Lee must have felt by being rejected. Literally the thought of it just traumatizes me of going back into my own past. I also have been given the unenviable task in my 30 seconds left, which I'm going to keep to 30 seconds, is just to flag up on the Bell and Tavistock case, which of course people will be aware is the puberty blockers case, because we have agreed that we just touch upon that case in this seminar. It's a very interesting case. Obviously that judgment definitely needs querying. It needs to be reviewed on a number of levels, and luckily it's going off to the appeal courts. And so inevitably we'll get something much more interesting coming from them. We don't really focus on the benefits of that case or the good bits of the case, which is, of course, they did say that under 16-year-olds should have access to puberty blockers if they needed them. But obviously they put this condition that the court requires that. The rather brilliant Naomi Wolf, for those of you who have read her work, do not be put off by any controversy that surrounds her. The rather brilliant Naomi Wolf has described that decision in such startling terms, where she puts it into the context of, the state, i.e. the courts, making these very, very personal decisions that are between us and our healthcare providers. And I think when you look at it in that context, and you look at how we need to preserve and protect that relationship between us and our healthcare providers, and you put it into the context of all sorts of issues, the most obvious one being the right to terminate a pregnancy, and the idea that the state could somehow find a way into that process and that relationship is really worrying. And there are many reasons to be worried about the current Bell and Tavistock case that aren't just about the denial of the trans experience and the trans kids experience that it so awfully embodies. So I think that is all from me, Mark, if that's okay.
Thank you, Jonathan. That was a journey, rather like the Strasbourg court's journey on trans rights and other things, that covered an incredible amount of ground. Thank you very much for it. The recent, in the sense in which you use it, shift towards better recognition of trans rights and the recognition of a broad spectrum of identities is definitely encouraging and shows the journey that a court can go on, as is the approach they're taking on free speech, both free speech for LGBTQ people and also recognizing that the same prohibitions on hate speech should apply to homophobic, biphobic, transphobic speech, as the court recognizes in relation to race, religion, and other protected grounds. And on that issue too, we've got current concern about what's happening in domestic courts, and recent case of Miller and College of Policing, in which Mr. Justice Julian Knowles gave a judgment which may well be defensible for free speech practitioners, but was deeply concerning in the way that it appeared to distinguish between the approach to hate speech on other grounds like race and hate speech against trans people. Okay, so very belatedly, and thank you very much for so many of you sticking with us to this point, I will come to questions. And what I propose to do is take 3 at a time and invite the panelists to give any comments. The first one is, and I believe I'm not sure whether our audience can now see it. I've said we're answering it live, but we're going to anyway. I'll read it out. My understanding from your explanation, I think this is to Alice, is that being non-binary was constructed by the court as analogous to being on the way to full transition, the A to Z analogy they used, in order to fit non-binary experience within the language used in Hansard. Whilst you said this might reflect the claimant's feelings about her gender, is this not a slightly uncertain basis for future claims by those who have a fixed non-binary identity and do not feel that they are on a journey with their gender? Second question, doesn't there need to be an impact assessment for other employees too, like the use of the loos? And third question, as a non-binary person, I'm used to having all identities outside of the binary ignored. It's really refreshing to see people address these topics with such legal precision, but also with such nuance. I guess that wasn't a question. But anyway, comment.
I can answer that question.
So I think it's natural for me to address the first question about how the court approaches the non-binary identity in the Land Rover case. I think the key paragraph is paragraph 178. And I do think that they use the language of A to Z but the way they unpack that there, I think, does give a fairly firm basis actually for cases going forward, because they say it could be somebody who describes as non-binary, not at point A or point Z, or someone who's gender fluid at different places between point A and point Z at different times, or as somebody who's transitioning, moving from A to another point, but not necessarily ending at point Z. So I do think there is that first recognition there that it could be somebody who's not at point A, not at point Z, but also not transitioning, that they're stable in a sort of interim position. So I do think that the judgment does address that, and that they do manage to extract that from the language in Hansard. I nevertheless think it's a good idea for the legislation to catch up. So I do think that gender identity as a protected characteristic rather than gender reassignment makes sense. I'll just run on very quickly to this point about impact assessment for other employees too, like the use of loos. I don't make any excuses for the fact that I don't think trans people pose a risk to anyone in using bathrooms of their preference. I know that some people disagree with that, but I don't see a conflict between particularly women's rights and the rights of trans women to use a women's bathroom. Trans women have been using women's bathroom for a very long time without that being an issue. I do recognise that some women don't share that view, and that there is in Schedule 3, paragraph 28 of the Equality Act, the carve out which allows for same-sex spaces if this is a proportionate means of achieving a legitimate aim. And I think that's what's really often forgotten in this debate, which is you can maintain a same-sex space if it's a proportionate means of achieving a legitimate aim. And my view is that I don't think it's a proportionate means of achieving a legitimate aim to exclude a trans or a non-binary person from the toilet of their preference on the basis that some people don't feel comfortable with that. There isn't evidence to suggest that there is a risk to women or other toilet users in these circumstances. And so without that evidential base, I just don't think it's proportionate, nor do I think it's legitimate to a legitimate aim sort of simply to advance people's kind of fear around that, although I appreciate that that's controversial. So, I mean, surely carry out an impact assessment, but I think the answer to that impact assessment is there isn't an issue with a trans person using the bathroom that they prefer to use.
Okay, would anyone else like to jump in?
I mean, I just to make the observation, or I agree with the observation that Alice made about the kind of clunky language of the GRA. You know, of course, it should be phrased differently. So. Okay,
so I'll take another 3 questions or comments. Firstly,
the Equality Chat, not the GRA. Sorry, no, sorry, go on.
Is there a case for abolishing altogether legal recognition of sex and identity and protecting personality as a characteristic instead? Secondly, I note that you seem to be associating queer with trans, but no mention of LGB. Would you see them included in your queering of the Equality Act? And thirdly, could the panel comment on the gender critical take that sex and gender reassignment in the Equality Act are mutually exclusive, and in particular, how can we combat that argument? I'm
kind of happy to talk about the personality one and about LGB. It's interesting about this whole personality point. I think the answer is probably no, for the reason that these are protected characteristics for a reason. They're characteristics that are vulnerable effectively in some sense, or in need of protection in some way. The Equality Act does cut both ways. The case that I think of a lot is, or not that I think about it a lot, the case I think of when I think about it cutting both ways is a straight person working in a gay bar in Brighton was effectively harassed for being straight, and was able to claim against his employer in that instance. And so it does cut both ways, and it's important to think though about the kind of effective purposes that it's meant to protect those who are in need of protection. And personality might be a bit too much of a nebulous concept in order to be protected by the law. I think, as acknowledged by the Feminist Jurisprudence Project, there are limits to legal reasoning that you have to operate within the structure, and it's not a perfect system that you're operating within, but hopefully that we can reclaim some of the tools. And I think the reality is that we can't reclaim all of the tools. talking a lot about queer, I think part of the reason for this is that there's not a lot of Equality Act cases about gay people in the same way there's so much more Article 14 cases under the ECHR. You know, we could queer so many of those judgments from an LGBT perspective, and I'm sure there's plenty of cases that erase the identities of bi people and lesbians and gay in the same way. But
well, Gareth's case.
Yeah, exactly. And I think that we chose these cases because they touch on really important topics and are quite important in terms of where we're at in terms of the debate around these issues. Well, debate or lack thereof. The whole point of this is that these people need protected, and it's just an important way of saying that this is the ways in which the law is currently failing those who are very vulnerable to media harassment and panic, moral panic at this time.
Well, I think we should set Alice and Donnchadh some homework, and they should come back and they should queer Gareth Lee's case. I'd really like to see that.
I could give you a Northern Irish edition as well, so I could queer it from a Northern Irish perspective.
If I can come in on this idea of personality instead of, say, gender identity, I think there's a really good reason not to go that route. I think that we can recognize that sexual orientation is a distinct thing, that gender identity is a distinct thing. And I think that to say that this can be conflated with personality is to really miss the essential aspect of these features of a person's identity. So even in the case, the passport case that I recognize where the court ultimately doesn't allow for a non-binary option in the passport, the court is very clear that somebody's gender identity is integral to their sense of self. And I think that there's a sort of a slightly pernicious tendency in some of the conversations to say, well, if you're self-IDing into gender identity, that's just like having a personality or choosing something, and I do think these are important, different and important ways. And as Don says, that people with gender identities that don't map onto perhaps what's acceptable socially have been the target of quite considerable harassment and hatred. And there's a reason to recognize that as a distinct group worthy of protection. In terms of the final question about what do we do about the gender critical take that sex and gender reassignment are mutually exclusive in the Equality Act, I think I briefly mentioned what's often relied upon in this kind of context, which is that part of Schedule 3, which is the carve out to say that someone who's providing services or somebody who's carrying out a public function can offer services or carry out their public function, offering that to us in a same-sex space without that discriminating against people who have the protected characteristic of gender reassignment, if it's a proportionate means of achieving legitimate aim. And as lawyers, we're really used to that language. And I think the critical thing that's missing entirely in this debate is, and I think this is, well, debate, there's just a lot of assuming of positions, is, as I sort of said before, that it's proportionate to exclude trans people and that there's a legitimate aim in doing so. And I think both of those can be pushed on really, really hard, because I just don't, as I say, think that there's the evidence to support that this is necessary to protect women's rights. And I say that as somebody with a very strong campaigning background in anti-sexual violence, who is very keen to ensure that women's rights are protected. And I think that really trying to frame it in terms of the Equality Act is a bit of a dodge, that really the underlying disagreement is about whether or not trans people pose a risk. And I think that's moral panic, just like there was moral panic about gay men in the military and gay men predating on young men and all of this kind of stuff. I personally think that that's the same. So I almost wonder whether saying pandering to the Equality Act debate is sort of a little pointless, to be honest.
Okay, thanks very much. Say we've had a couple of comments about the use of the word queer. One asking why we keep on using this hateful word. From my point of view, the very reason that Jonathan gave why it was used as an instrument of oppression was how I found it incredibly empowering growing up, when Queer Nation and other direct activists started reclaiming it. If it wasn't an object, if it wasn't a weapon of hate, then there would have been nothing to reclaim. But Jonathan, what do you think?
Well, I'm just looking at the question that somebody also put to me on it. I think it is part of our identity. We can't escape it, and it's the thing that we feared all our childhoods and as we grew up, and so therefore I think to somehow reclaim it to the extent that that's possible is the only way of dealing with it. It's much better to reclaim it than to have it there lingering in the sort of ether. I mean, it's interesting. I mean, there's all this furore going on around Naomi Wolf and the way in which she, the work that she's done on sodomy in the 19th century. But it's worth reading her book, because actually what she does is she presents that 19th century sodomite as the sort of bogeyman that is the spectre that hangs over us all. The idea that we were just thrown in with these groups of terrible criminals that raped and abused and hurt people, and we were put in there with them, and that is the legacy that we still live, and that is where the queer comes from. And so if we can somehow, by reclaiming it, soothe ourselves from that awful legacy, then that's great. I don't know if we really can, but I don't think we can't escape queer. It's just there. It's a fact, and therefore the only thing we can do if we're going to get anything from it is to reclaim it. But it may be a generational thing. I pray to heaven, not that anyway, whatever. I pray to something, or don't pray. But these, the kids that are growing up now, and maybe even Donnchadh and Alice, just didn't experience what we did experience around that horrible word. And it is a horrible word, and I don't find any fun in it, and I don't find it light, but I find it a really empowering reminder of where we've been and where we've come.
I think that's a really interesting take. I have to say, for me, it's a very positive word that signals inclusion in the LGBTQ community, and also respect for intersectionality. However, we've now gone more than an hour and a half, and I think I've used all my injury time, so I'm going to wind up now.
Can I just say one thing?
Yes, sure.
Just one thing. For those of you who are interested in the Bell and Tavistock case, there is an event that Bristol University are organising. I think in the beginning of March. I think it's the 3rd of March. So I'm going to recklessly say, if you contact me at my Dowd Street account, I'll forward you the details, which I'll regret doing now. And the other thing is, Bristol is running an event tomorrow called What Next for Queer Britain, if we want to carry on that discussion around queer. And I see what Mark's saying, and I see the way Alice and Donnchadh so warmly embrace the term queer, that it's inclusive, but it is also traumatic. And I get what Mark says about it being the kind of quintessential intersectional idea, but it is also profoundly traumatic. That's it from me. Sorry.
Well, I think I'd better say that's it from me as well, in case I provoke any further comments. Thank you very much to all our panelists, and thank you for so many of you, over 100, sticking with us to the bitter end. Thank you. Okay.